A bill requiring students in South Carolina public schools to use the restroom of the sex on their birth certificate cleared the state Senate today. It's something Republican lawmakers have been working for months to pass now, while Democrats have called it a political stunt. State House reporter Stephen Biddix has been following the bill and has more on what's next.
Right now, a temporary state policy requires students to use the restroom for the sex they were assigned at birth. This bill would make that permanent. This has been a top priority for House and Senate Republican leadership. School districts out of compliance could see 25% of their state funding withheld. Individuals could also sue if they encounter someone of the opposite birth sex in their restroom. Senate Majority Leader Shane Massey says it's simple.
Do you know how a school, a K-12 school or a university could avoid a lawsuit or the financial penalty?
Comply.
Follow the law.
Yeah.
Comply with the law.
After schools raised concerns about construction costs for new facilities, Senate lawmakers amended the bill. Under the change, schools would be allowed to offer a single-use restroom, temporary private access to an existing facility, or a portable option instead.
This would allow for immediate compliance if we're just talking about putting up a sign or changing the designation of one room versus another, or if you have very small buildings that maybe not have a bathroom at all, they can buy a porta potty.
Democrats argue the bill targets the transgender community. Concerned, students could have to use a porta-john. Senate Minority Leader Brad Hutto is frustrated lawmakers have spent this much time on the bill.
We're the fastest growing state in the country. We're at war. We got people paying over $5 for diesel. We got all sorts of issues that we could deal with, and this is the most important thing we could put on special order.
Senator Ed Sutton of Charleston says he thinks the bill would face a legal challenge, adding that it violates Title IX, the federal law banning sex-based discrimination in education.
As the Fourth Circuit's already ruled it unconstitutional, the Supreme Court refused to hear it. This law is never going to go into effect. We've already been down that road, so a lot of this is just wasting time. Because
the Senate changed the bill, adding in those accommodations, it now goes back to the House, where House members can either agree with the Senate or make further changes and send it back again. Reporting at the State House, I'm Stephen Biddix.